Support comes from St. Louis Public Library Foundation, helping the library serve children and their families with programs and services needed to become lifelong readers. More information about the foundation is at slpl.org.
This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky. Missouri Governor Mike Parson and St. Louis County Executive Sam Page both say they have the right to choose the next prosecuting attorney. What does the law say? A lawsuit seeks to overturn various Missouri laws blocking abortions. It was pitched as the next step after voters approved a constitutional amendment enshrining reproductive rights in the state constitution. But there's been no action in weeks. What happens if the judge doesn't act for months on end? And the Rams want to buy their former training facility for just $1. Could they manage to get the matter kicked out of court and into private arbitration? You know, these are matters that only expert lawyers can shed light upon. And today, we have three here with us. Yes, today is our Legal Roundtable. And today, in a rare treat, we are joined by Mary Anne Sedey. She is a partner at Sedey Harper Westhoff, a nationally recognized labor and employment lawyer. I am constantly trying to get her to come on the show, and I'm so excited that she is joining us today. Mary Anne, welcome back.
Good to see you.
And we are also joined today by Liz Lenivy. She's an attorney at the Simon Law Firm in St. Louis. She specializes in medical malpractice, product liability, personal injury. She knocked it out of the park the last time she was here, and she is back for a second go-round. Liz, welcome back.
Thank you. Glad to be here.
And last but never least, one of my favorite panelists. This is Dave Roland, Director of Litigation at the Freedom Center of Missouri. Dave, thanks for joining us.
Always a pleasure.
So attorneys for Governor Mike Parson and County Executive Sam Page were in court this very morning. They were arguing a case with big stakes for St. Louis County. And I am talking, of course, about the battle to replace prosecuting attorney Wesley Bell. He's headed to Congress. Who gets to choose his successor? Page and Parson have nominated different people to replace him, and Attorney General Andrew Bailey has sued to block Page's pick. That's what took us to court this morning. Now, at this hearing, Page's attorney pointed out that throughout Missouri history, the governor has never asserted the authority to appoint a prosecuting attorney in a county that has its own charter. Judge Brian May said, "So what?" So the Post-Dispatch kind of seized on this quote. Sounds bad for Page's team. Liz, what's your take on this? Does this mean that May has decided that Sam Page has no case? He does not get to make this appointment?
I certainly don't read into Judge May's comments in that way. And it's possible it's because I've probably been asked by a judge, so what, before myself. I think that this is a really novel issue. It's a challenging issue. And the judge, in his discretion, is seeking to challenge the attorneys, as he should. So I don't read into it.
Okay, so this might be just a case of Socratic method questioning. What about this idea of precedent? Does the precedent matter here, Dave? If this is how Missouri has always done things, is that something that the judge should be considering?
Well, I think it's important to take a step back and understand that there is a constitutional provision in the Missouri Constitution that specifically says the governor is supposed to make appointments to fill vacancies, even in local offices. Beyond that, the state legislature passed a statute that specifies that if a vacancy happens for any cause in the office of prosecuting attorney, the governor is supposed to make that appointment. So I think that the county is really facing an uphill battle here as far as what the Constitution says and what state law says. Now, they did point out that there have been any number of local prosecuting attorneys who have been appointed by local executives. That's not really a legal argument, though. And so I think that that's what the judge was picking up on. And I also think that the St. Louis County attorney may have overstated the situation because folks in St. Louis will remember we just recently had to replace a circuit attorney. Who made that appointment? The governor.
See, what I was told at that point, though, is that circuit attorney is a different kind of office. St. Louis has the only one in the entire state, whereas prosecuting attorney, you see those all over the map.
So the title for the office is different. The function of the office is the same. So St. Louis City functions as a county, even though it is an independent city. And so the title of the office in St. Louis City is circuit attorney, but it is effectively the same as prosecuting attorney in any other county in the state. And of course, St. Louis City is a charter form of government the same way that St. Louis County is. So the way that I explained this to my wife when we were talking about it is the old adage is, if the facts are on your side, pound the facts. If the law's on your side, pound the law. And if neither is on your side, pound the table. I see a lot of table pounding from St. Louis County's attorneys.
Mary Anne, what's your take on this?
Well, I think, unfortunately, what we've got going on here is a political dogfight when we ought to have a reasoned consideration of who ought to be in that position. I see it a little differently than Dave does. The county charter says that the county executive appoints the prosecuting attorney, and the Constitution and statutes refer to the fact that the governor has the right to appoint all these vacancies if there is no other law to the contrary. And to me, that's a very important phrase. So I see it differently than Dave does, but, we're going to have a judge tell us what the answer to that is.
Yeah, so you would be pounding that fact. Liz, where would you fall in this? We have a clear disagreement here between our two esteemed panelists.
So I'd like to fall directly into the middle in that I tried really hard to look up all the statutes and what the law says. I think that both sides do have a compelling argument. I think that the law is unclear at this moment. A point of clarification, though, that I thought was interesting, and not to dogpile you a little bit, Dave, but I guess a point to Mary Anne is that, as a city resident, I was thinking about the fact that when Circuit Attorney Gore was appointed, that was a pick made by Governor Parson. So I took a look at what the city charter says, and there is a specific carve-out for the role of circuit attorney. So that makes sense to me as to why Mayor Jones could not make that selection. So I do think that might be, I guess, a point of argument for the county. But again, as far as comparing the two, I think they're in direct contradiction to each other a little bit. But as Mary Anne said, Constitution does say governor shall fill the vacancies unless otherwise provided by law. We have to read into that whatever the drafters meant.
Yeah, there is that unless. Dave.
So to address the question about what the charter says, the charter does say that the county gets to determine how the prosecuting attorney is going to be chosen. There's a difference between the initial matter of appointment and filling a vacancy, and I think that that's where the disconnect is. The city is arguing very much that they get to choose how prosecuting attorneys are going to be selected, but that does not address the question of whether there's going to be a vacancy in that office. When there is a vacancy, both the Constitution and state statute, which, by the way, trumps a charter provision. Charter authority only extends as far as the Constitution mandates that it extends, or as far as the legislature allows it to extend. And so if the legislature has adopted a statute that says vacancies will be filled this way, no number of charter provisions can change what the legislature has said is the rule statewide.
Mary Anne, I see you looking a little skeptical.
Well, a charter is a law. And the Constitution of the state of Missouri says, unless otherwise provided by law. So, I think both sides have a lot to say here. I do not agree that this is a slam dunk for Parson.
So it seems like this could open a can of worms if it turns out, if the judge rules in favor of the state and says the governor gets to do this. There's so many prosecuting attorneys that were appointed via this county charter provision. Attorney Gerald Christmas told a reporter on my team at St. Louis Magazine that he would sue to kick out the convictions of all of his clients in St. Charles County that were handled by the current prosecutor Joe McCullough, who was recently appointed by the county executive there. Could you see some complicated things coming out if it turns out that the state wins this round? Mary Anne?
Well, I don't think it's going to depend on whether the state wins this round. It's going to depend on whether the state wins the ultimate round,
Missouri
which
Supreme
is
Court?
At the Missouri Supreme Court, right. And, I think that that's an argument, or at least a consideration, that is going to be in the back of the minds of people making these decisions. And by that, I mean judges at various levels.
For those of you listening, you may have a question for these very smart lawyers we have digging into the law here. You can call us at 314-382-8255. That's 382-TALK. And yeah, we'd love to have you join our conversation if you have a question about this topic. Mary Anne, you were actually at the council meeting last night where a complication for Sam Page, the county council, has now voted down. They say they don't approve of his pick for this, which I feel like if I were Governor Parson's lawyer, I'd say, yeah, the own county council doesn't even want this guy. What did you witness as you were there?
Oh, I witnessed a political dogfight. It was very discouraging to see the way the county executive's recommendation for Court Van Ostren was handled. I mean, it was extraordinarily disrespectful. And what's going on is we just have a fight in St. Louis County between Sam Page and the council. And there's no accounting for the kinds of positions people are taking here other than to say it's just bald politics. And it was not fun to watch, frankly, I think, for anybody who was there. Just so you understand, the council was not voting last night on the nomination. In fact, they've taken the position that until there's a vacancy, they can't vote. But it was a recommendation of the committee of the whole, which is a little technical. But it certainly is a sign of what they might do.
Well, Mary Anne, thank you for being our St. Louis County correspondent. It's great to have that intel from the meeting last night. You know, there's more legal news out of St. Louis County. Maria Chappelle-Nadell is a former state lawmaker. She's a former aide to Councilwoman Rita Hurd Days. Maria was fired in 2022. Last year, she won a $77,000 settlement with the county. That includes the legal fees. Now, news of this settlement was swiftly leaked to the media. She's now suing, alleging retaliation. Liz, do you think she has a good case?
Is it bad if I defer to Mary Anne as the labor and employment specialist? I mean, having read the petition, my initial thought is not really on count one, but maybe on count two.
And this count two, was this about the public records that
Correct,
she was
the
seeking to
Sunshine
obtain?
Act.
So let me quickly defer over to Dave, because I understand, Dave, you have some real knowledge of this Sunshine Act stuff. And we'll go back to Mary Anne on the employment in just a moment. You think she has a good case there?
Yeah. So not only do I deal extensively in the Sunshine Law, I worked particularly with Maria trying to get records from St. Louis County on this. I think under the law, she has a very strong argument. Their primary response when she was asking for records is they were claiming the right to retain the records or to withhold them on the basis that the investigations were still active, which I do not believe is the case. I don't think that there's any legitimate argument that these investigations were still active. We even went so far as to try and get some of the family members from the persons who were related to these records to request them, because under the Sunshine Law, family members have a fairly absolute right to obtain these records, and the county was still unmoved. So I think that there is a pretty strong argument here. It's not a 100% slam dunk, but I think it's a very strong argument that she was entitled to those records and that the city, or rather the county, should have produced them.
So that could be a strong claim, but the sort of leading claim on this lawsuit is that they retaliated against her by leaking this settlement to the media. Mary Anne, you handle a lot of labor and employment cases. I imagine a lot of settlements. What do you make of those allegations?
Well, the first thing that confused me, and I have to tell you, I haven't seen the settlement agreement, is the fact that there was any claim that the settlement could be kept confidential, since the county is a public entity. Every client that I've ever had where there's been a public entity on the other side, we've always understood that if people made the right kind of requests, they could get the information about the settlements. But again, I don't know the specifics of the settlement. The other thing is, ultimately, she's got to prove it. And, people say to me, they'll call and say, oh, so-and-so did such and such, and I want to sue him for defamation. Well, those kinds of claims where supposedly somebody said something they weren't supposed to say, boy, those are tough claims. So,
Dave?
As far as the settlement agreement is concerned, the Sunshine Law specifically says settlement agreements are supposed to be public records after they are concluded, unless there is a separate order by a court to close the record upon written finding that the adverse impact to a plaintiff clearly outweighs the public policy considerations. And in any event, the amount of the settlement has to be made public. So I think that it is a challenging argument to make that it was somehow improper for them to publicize the settlement agreement itself.
Boy, that's an interesting fact there, Liz.
And I think the one additional thing that I guess garnered from reading the petition and sort of my confusion and reading some of the facts under the retaliation claim was that it's always been my understanding, granted I don't practice employment law, but it's always been my understanding is that for a retaliation claim under the Missouri Human Rights Act, you have to be an employee. And at least as I was reading the facts, it seems like she was alleging retaliation after the fact. So that's where I got really confused and sort of bogged down in the details and maybe got myself lost in the law a little bit. But that's sort of what my thought was of, I don't think this is a really strong claim.
Liz, that's a great question. Mary Anne, do you think that would hurt this claim? She's a former employee. Let's say there was retaliation. Can you get away with retaliating against a former employee in a way you maybe couldn't with a current employee?
Well, I'm going to admit that I don't know the answer to that question. And I think there may be differences between state and federal law in terms of that question of whether a former employee can bring retaliation claims. I'm almost positive that under federal law you can bring that kind of claim. Whether you can bring that under the Missouri Human Rights Act, I'm not certain.
We're talking today to our Legal Roundtable, 3 top attorneys with us today. That's Mary Anne Sedey. We're also joined by Liz Lenivy and Dave Roland. We're going to take a quick break. When we come back, we'll discuss how Missouri's constitutional amendments, newly approved by voters, are going to get sorted out in court. And after that, we'll talk about the Rams' attempts to move their latest lawsuit out of court and into arbitration. This is St. Louis on the Air on St. Louis Public Radio.
If you have a smart speaker, you have access to the entire world of NPR and St. Louis Public Radio. All the latest news and all the captivating stories. Activate our voices with yours by telling your smart speaker to play St. Louis Public Radio.
Welcome back. I'm Sarah Fensky, and I'm here because today is our monthly Legal Roundtable. We always do this in one of the last weeks of the month. We find a date for it. This is not quite the last week, but give us this. We had to knock this out before the holidays, and so I'm here today with 3 top attorneys digging into all facets of the law. That includes Liz Lenivy, an attorney at the Simon Law Firm in St. Louis. She specializes in medical malpractice, product liability, and personal injury. We're also joined by Mary Anne Sedey, who's a partner at Sedey Harper Westhoff. She's a nationally recognized expert in labor and employment cases. And we're joined by Dave Roland, director of litigation at the Freedom Center of Missouri. So Dave, I'm going to put this one on you. Missouri voters last month approved a constitutional amendment guaranteeing a right to abortion. They also passed a new state law guaranteeing sick leave and raised the minimum wage. But each initiative's victory has now led to a lawsuit, and now it's judges who will help determine whether either victory means anything. So let's start with abortion. Now, in this case, it's the advocates who pushed this constitutional amendment who filed suit. They want the Jackson County judge to declare the state law invalid based on the amendment. This amendment has supposedly now gone into law under its own verbiage. And yet it's not law in practice. I guess let's start with this idea of this proactive lawsuit from the winners. Do you think this was the right route for them to go to get what they wanted in terms of state law?
I think it was the only route. The situation that we find ourselves in is Missouri voters have adopted this new provision, a very powerful provision, into the state constitution. But in order to enforce one's rights, you have to have the state take action against you in most circumstances. Mm-hmm. Now, the penalties that people would be facing for trying to exercise this newfound right, if the state disagrees that the right applies, could be extreme. So we're looking at potential felony convictions. We're looking at all sorts of disciplinary issues. That
if, say, a
people
doctor just went ahead and performed an abortion. Okay.
Exactly. So
Yeah.
the stakes are really high. And under those circumstances, rather than requiring people to act on faith that the Constitution is going to protect them, you can go and ask for a declaratory judgment. Say, court, we need clarification. Do these laws apply the way the state says they apply or not? And by seeking that kind of a declaration, you can resolve the dispute without having someone put themselves at risk by violating the laws that to this point are still on the books as far as restrictions on reproductive freedom. So I do feel like in order to resolve these issues quickly and cleanly, this really was a step that had to be taken. However, I think that until we have clarification from the courts, either from the Jackson County judge or more likely ultimately from the Missouri Supreme Court, someone's ability to exercise their right to reproductive freedom really depends on their risk tolerance.
Yeah.
It is one thing to know that you should have a protected right under the Constitution, but to take that leap of faith and say, I'm going to exercise this right even knowing that the government may well come after me, that's a lot to ask of anyone.
Yeah.
And so I find it difficult to blame the providers and those who might be looking to exercise their right to reproductive freedom for being very cautious about doing so. But at the same time, I will say I think that this is one of the more ironclad constitutional rights I've ever seen. It does put the right to reproductive freedom on a level above any other constitutional right in terms of the protections courts are supposed to apply here. So we'll see what the courts end up doing. But I think on paper, it is a very solidly written amendment.
Yeah, it did seem like this amendment was going to lock in this right. And call me an impatient person, but I'm ready to say, what is taking this circuit court judge so long? We know this is going to end up at the Missouri Supreme Court. Why doesn't she just quickly rule? Mary Anne, would you have thought that there would be a circuit court ruling by now?
You know, judges have their own timetables. There's nothing that lawyers can do to hurry them up or slow them down. And, you know, maybe this judge is trying to be extraordinarily careful. It's a very important issue. And I can see that you'd want to take your time and get it right. On the other hand, time's a wasting.
Time is a wasting. And does it matter what the circuit court judge even writes if it's going up to the Missouri Supreme Court anyway?
Yeah, I do think it matters.
It does matter. Why does it matter?
Because I believe that once there's a ruling, I believe the providers will feel much likelier to begin to provide service. I mean, that what I have heard from those people is that they are ready to go. Mm-hmm. But they're being careful, and that's really prudent.
Okay. And they want this ruling. The judge has been sitting on this a little bit. I know people were really thinking that, I believe it's a she, Jerry Zhang, they were thinking that she would rule by, I believe, December 6th, which is when the law says that it goes into effect. Liz, could she just sit on this for a year? And we'd all just be hanging in limbo.
I can't imagine that the judge would do that. I just don't think that that's a situation that we're going to be facing. I imagine that the judge is aware that not only are the litigants looking at her, frankly, the residents of the state, if not the country, are looking at her. Because if we saw what happened in other states where litigation happened, and that's why the first question you ask is, was litigation sort of, we knew it was going to happen? Yes. I think the simple answer is yes. We knew that this is where it was going to end up. But I think the judge can understand that the country is looking at her right now as well. And she wants to get it right. She wants to do it well. But I don't imagine that this is going to be dragged out for so long because people are waiting. And this is a situation where it's not just the litigants that are waiting, but there are residents in Missouri who want to know what's going to happen. There's providers in Missouri who want to know what they can and can't do for their patients. So, but I do believe that she's approaching this with due deliberation.
Do you share Dave's perspective, that this is pretty much a slam dunk, that reading the letter of what the voters approved, we should have abortion rights in Missouri? There's not wiggle room in how this was phrased.
I don't know if I necessarily believe it's a slam dunk. I think I've practiced long enough. I just don't feel like anything's a slam dunk anymore. But I do believe that it was a very strongly worded amendment, and the voters of Missouri voted in favor of it. And my understanding has always been that at least courts in general are reticent to overturn the will of the voters.
Dave.
So I want to clarify a little bit what I think is a slam dunk. So,
And I should say, I think I used that phrase, not you. So my apologies.
So the right to reproductive freedom is absolutely part of the Missouri Constitution now. The question is, to the extent that the amendment does allow some level of regulation, and it does allow some level of regulation, where will the line be drawn between what the state can lawfully regulate and what it can't? And so that's where the ambiguity lies. I think that to the extent that abortion providers are feeling like they can't provide any services under the circumstances, I think that's perhaps an overabundance of caution. I think that the Attorney General's office has made clear that they understand that some level of abortions have to be permitted under this new constitutional amendment. But again, the devil's in the details. So one of the provisions that's currently at issue is the waiting period that the legislature had adopted, and whether abortion providers can disregard that waiting period now. Well, one of the things that the amendment specifically says is that the right to reproductive freedom shall not be interfered with or delayed. Well, when you factor in the question of, well, you've got to wait 72 hours, that sounds to me an awful lot like a delay. But that's where the uncertainty lies. Will the courts agree that 72 hours waiting period constitutes a delay that's prohibited by this provision? And we don't have any precedent to build on from that. They're having to figure this out as they go. And so one of the things that I've reminded people is that if you go to the U.S. Supreme Court building in Washington, D.C., you'll see turtles all over the building, because that is a symbol of the fact that justice moves slowly. And that is a feature, not a bug. When justice moves at a deliberate pace, it makes it more likely that you'll come to the correct conclusion rather than an expedient conclusion. And so, although I certainly sympathize with the people who are frustrated with how long it's taking, on the other hand, I think that what it indicates is that the judge is taking seriously her responsibility to be deliberative and to come to the right conclusion, even if it's going to be reviewed by the Missouri Supreme Court ultimately. And so, again, I don't think it's going to take a year. But I do think that as easy as it would be to be impatient, I think that it's actually a heartening sign that the judge is being very careful and thoughtful in how she's dealing with this.
I'm getting new sympathy for Judge Zhang, who I came in thinking, what is taking so long? I'm beginning to realize there's a lot more nuance here than may be available on first glance. Mary Anne, I'd love your thoughts on what Dave just said.
Yeah, I think that what Dave said made a lot of sense. The other thing that I think is interesting is if you look at the list of restrictions on abortion that currently exist in Missouri, I wouldn't be the least bit surprised to see that she makes distinctions. That the 72-hour period may go down, but the requirement of licensing for the clinics and availability of hospitals in, within a certain amount of distance, she might hang on to those. I really don't know. I'm just saying there are distinctions that you could draw between these various kinds of current existing law. But the fact that without delay are the words in the constitutional amendment is going to be very helpful for the proponents.
So that's the one constitutional amendment approved by voters. We also have this ballot initiative, the minimum wage lawsuit. This one is different in that this litigation is brought by the people that didn't want this to go through. They are trying to challenge that this passed, not figure out the details of what it means because it passed. Dave, is there any sort of good case here? What do you make of this one?
Well, let me start by saying they're saying that this new statute is invalid because it violates some provisions of the Missouri Constitution that restrict how you can pass laws, what kinds of laws can be passed. So in particular, they're saying it violates what's called the single subject rule. Now, the reason that we have this is because in the usual legislative process, there can be pressure on legislators to add in provisions to a very popular bill. So the addition may not be popular. Maybe it couldn't pass on its own. But if you can attach it to a very popular bill that's very difficult for other people to vote against, then you get your pet idea through, right? And when the Missouri Constitution was drafted, they said, we don't want that. We don't want this log rolling. We don't want people sneaking amendments into law. And so that's why we have this protection. All of that said, Missouri courts have been, shall we say, a little bit lax in how they apply the single subject rule. They've provided a lot of flexibility. And under these circumstances, where effectively the argument is that, well, you have not only adopted an increase to the minimum wage, you've also put some additional restrictions on businesses about how they have to interact with their employees. I find it fairly easy to see all of these things falling under one general umbrella. They're all within one particular chapter of the Missouri statutes. And so, quite frankly, I'm not certain that there's a really strong case here. We'll see what the courts end up doing with it, but I would not hold out a lot of hope that this lawsuit is going to be successful.
Liz or Mary Anne, do you and either of you want to argue with Dave?
No.
All right. Well, that makes this a perfect time for a break. We're talking today to our Legal Roundtable. That is Dave Roland. We're also joined by Liz Lenivy and Mary Anne Sedey. Coming up next, the Rams attempt to go to arbitration, and also a student sues after her free speech rights were violated. This is St. Louis on the Air on St. Louis Public Radio.
The Gateway brings you the day's news each weekday from around the St. Louis region and the state capitals in Jefferson City.
Our schools are accredited. We don't need this bill.
And Springfield.
How many more years must pass before lawmakers see time is of the essence?
I'm Abby Larico. Join me each weekday for The Gateway on the STLPR app or wherever you get podcasts.
Welcome back. I'm Sarah Fensky. I'm here for our monthly Legal Roundtable, joined today by Dave Roland, Director of Litigation at the Freedom Center of Missouri, also joined by Mary Anne Sedey, who specializes in labor and employment cases for Sedey Harper Westhoff, and Liz Lenivy, who's with the Simon Law Firm and specializes in medical malpractice, product liability, and personal injury. So we're about to talk about a case that falls into nobody's direct area of expertise, but I know everybody knows enough to get us through this. This is the St. Louis Rams are trying to exercise the option to buy their old training facility in Earth City for just $1. Now, they previously took this case. They got it into arbitration. They won the right to make that purchase. Well, then the regional entity that owns this facility, they proactively sued the Rams in October. They argued that the settlement that the Rams made with the city and the county a few years back invalidated that $1 option. Now, again, the Rams tried to get this case to arbitration. This time, Judge Jason Sangheiser said no. Mary Anne, it feels like businesses are always trying to go to arbitration. What's that about?
Oh, it's about a lot of things. One thing it's about is secrecy. Businesses prefer that when somebody says they did something wrong, they get to have that fight occur in private. We see this a lot in the employment area. These arbitration agreements that people are required to sign as a condition of employment that say that they will not bring a lawsuit. They will take whatever dispute, even statutory civil rights claims, to this private court. There's a lot of problems with that. People don't know who's up to the bad stuff. You know, one of the essential principles of our system is these open courts, and they give important information to the public about what's going on. So that's one big problem. You don't get a jury of your peers. You get some lawyer who, frankly, is almost always bought and paid for by the employer in the area that I work in. And, you know, I'm not trying to say that these arbitrators are all, you know, bought and paid for. That was a smart aleck remark for me to make. But, if you know that your business comes from the same source over and over again, it's hard to be truly neutral. So there are a lot of problems with arbitration from the point of view of individuals wanting to bring claims.
Yeah, I mean, you make a compelling case because if a business is forcing me as, say, a former employee into arbitration, they're hiring the arbitrator. They're the ones running that process.
They're paying the arbitrator for sure.
Okay.
The selection of the arbitrator is usually a mutual thing. There's various ways it can be done. But in the long run, how often am I going to be hiring an arbitrator? Not very often. Whereas the big corporations that have these dispute resolution processes that are mandatory, they're going to be hiring arbitrators all the time.
I'm thinking about the Rams' first lawsuit. The Rams didn't file this lawsuit. The city and the county sued the Rams. This ended up in front of Judge Christopher McGraw, who, by all accounts, is a good jurist. But, he ruled against the Rams multiple times. The people of St. Louis started getting excited. We are all thinking, okay, we see a payday. Well, it ended up leading to this $790 million settlement. Liz, do you think that case would have gone differently if instead of a judge who lives in the city of St. Louis has to be retained by the citizens of St. Louis, that there's an arbitrator there?
Oh, that's a tough question. I don't want to, imply anything into Judge McGraw's ruling. I think that the issue or the thing that we see oftentimes is that, at least as a plaintiff's lawyer, why I try to avoid arbitration is I want my cases heard in front of a jury. And that's because I think a jury of 12, especially within the community that they work and live in and have expectations of for corporations or whoever may be a defendant or plaintiff in a case, they are typically going to render a higher verdict than what an arbitrator may agree to. So I think that by having that pressure of having to potentially face a St. Louis City jury, that probably, I would presume, pushed the Rams and their attorneys into settling that case. I don't want to say whether they would have fared better or not, because ultimately a settlement is something that all the parties agree to, right? Yeah. It's not like a jury held them accountable for what they did to the city. It was them saying, this is what we'll pay you in order to avoid any further litigation. And so, I think my trouble with arbitration is the same that Mary Anne is. And I've never arbitrated a case. I try really hard to avoid arbitration. They don't often come up in my cases. But it's the same issue of we want these types of cases public. We want a jury, the community, to be able to weigh in on what is and is not acceptable behavior in our communities. So,
yeah, as a juror, I think you can get offended. How dare you do this to my neighbor? Whereas maybe an arbitrator is going to have more of a cool neutrality.
In my cases, discrimination is often a matter of pattern. So, a company that is going to discriminate on the basis of race or sex may do that repeatedly. And the community needs to know that. Whereas when you've got private arbitration, the community never learns that. And even from the point of view of a lawyer bringing these claims, I don't know much about what goes on at these companies where arbitration is the norm. I have a real feel in St. Louis for what goes on in various corporations because, you do this long enough, you begin to understand certain patterns. So it becomes important for lawyers, but it's also important for the community to know what these big companies are up to.
Boy, I'm sure not going to argue with that. I thank God every day that court proceedings are open to journalists and members of the public, that these filings are open to journalists and members of the public. It's a great thing about America right there. Let's talk about when America goes a little more awry. Dave, you filed a lawsuit on behalf of a student in Cape Girardeau County this past month. This was a jaw dropper. I got to say, when this hit my inbox, I was like, oh boy.
Yeah, I felt like it was a pretty stunning situation, and that's part of why we got involved. So one of the biggest issues in American constitutional law over the last decade or so has been to what extent schools can punish students for behaviors or speech that takes place well away from the school. There was a case just a couple of years ago involving a student who was upset about not making the varsity cheerleading team. She unleashed this expletive-laced tirade on social media, and the school suspended her for it, and the U.S. Supreme Court says, you can't do that. Yeah. Schools do not get to police student speech 24 hours a day. But the Supreme Court left an important hole in its opinion where it said that they were leaving open the possibility that schools can impose punishment if there was a disruption of the school environment. So what happened in Cape Girardeau County, people may not recognize that around the start of the school year, there were a number of threats circulating on social media, not just in Missouri, but all over the country, where people were suggesting the potential for violence at various schools. Our client in this case was a 12-year-old who had heard about these threats. The school district had actually emailed parents and said, if you see something, say something kind of situation. The student's mother had told her about this. They had a separate security scare in their own neighborhood, so she was kind of on edge. And she was on Snapchat, and she saw somebody post something to the effect of that they were going to shoot up the Jackson school. Well, she lives in Jackson, Missouri. And she was worried about this. And so she reached out to one other student in a neighboring district that had been kind of keeping tabs on all of this and says, hey, I saw this. Is this real? And the other student said, well, do you have a screenshot? Well, she didn't take a screenshot. And so what she did was she took a picture of her own ceiling and kind of recreated the message that she saw. And it's very clear in the message between these two that she was not making a threat herself. She was trying to explain what she had seen. She sends it over to the other guy, and he says, well, what was the name associated with it? She says, I don't know. It said unknown. That's the end of their conversation. Unbeknownst to her, he then posted her picture with her name attached, making it seem as though she was the one who had made this threat. And so the school finds out about it. They shut down classes and extracurricular events for the next day. But very, very quickly, the police department looks into it and they find out, oh no, we understand this whole situation. We know this student never had an intention to threaten anybody, and the police department exonerates her. The school district, not so much. The school district calls her in. She explains exactly how everything went down. Her story is corroborated, and they still decide that they're going to suspend her for an entire school year. 180 days. We appealed it, and at the appeal, both the principal and the superintendent acknowledged, yeah, there's no evidence that she was intending to cause any harm or panic. She only sent it to this one student, but we have a zero tolerance policy, and that means we're going to stick with the suspension. And so we filed, we being the Freedom Center of Missouri, we filed this lawsuit on a couple of grounds, on First Amendment grounds, but also on due process grounds, because the school's own policies say that the district only had authority to punish activities or behaviors that happened at school, on school transportation, or using school technology, and this situation didn't fall into any of those. And to the extent that they identified specific policies, her behavior didn't really fall into either of those. So the false alarm policy specifically says that you have to cause a false alarm with the intent to frighten or disrupt, and no one is suggesting that she had that intent. And then when it comes to disruptive behavior, the specifics of the policy say, well, we're talking about if you are disrespectful for a teacher, or if you, do something that's designed to disrupt the school environment, which again, no one is really suggesting. So our argument is number one, the school overstepped its bounds by reaching outside of its own jurisdiction. But number two, they're attempting to punish her for an alleged threat that was never considered to be a threat by anyone in the first place, not really. And based on some recent Supreme Court cases, we feel like we've got a really good argument. But it's always a challenge when you're fighting against a school district, especially a school district that they are bound and determined that they did the right thing.
Right. But you talk about the juries, Liz, that a jury will hear a case. It seems like a jury's going to go, a year suspension for a 12-year-old writing a confusingly phrased message on Snapchat? Do you think this is going to offend the conscience of a member of the community?
I do. And what strikes me hearing this story, Dave, is that it sounds like this girl was actually trying to do the right thing. Yes. Right? She was trying to alert whoever it was that was sharing this information for something that is a really scary reality that kids have to face in this country. And it really blows my mind that the school district is doubling down on this in the way that they are. Again, when someone was trying to do something good, and probably, in her mind at least, trying to potentially save lives and keep people from getting injured, even keep herself from getting injured or hurt. So that's a crazy story.
Yeah, this is one of these where it's like, well, you couldn't make up this fact pattern. A jury may enjoy this one. Maybe they'll settle with you before it gets there.
Well, so part of the reason that we took this on, though, is that we are seeing more and more school districts reacting like this. There was a situation over on the west side of the state where a student was just fooling around and hot glued together Dr. Pepper cans into the shape of a rifle and posted it on Facebook or some social media, and the school suspended him. Like, there was no suggestion that it was a threat. Like, it was just got a wild idea to glue together these soda cans in this configuration. And so I don't believe that there's been a lawsuit filed on that. But I mean, it's another situation where its behavior completely outside of school wasn't intended to cause any kind of a panic, and yet the schools feel like they need to take aggressive action against the students, and that is a constitutional problem.
I will say I can see why the schools are on edge. I mean, some of the issues they're dealing with. But
and one of the things that we've tried really hard to impress is we are not criticizing the school in any way for reacting the way that they did before they had the full information. Like, we want our schools to be carefully attuned to student safety. But that does not necessarily justify the punishment once they had all the facts.
Yeah. Well, this is going to be an interesting one to follow. I hope you'll keep us updated as this one works its way through the courts. So we just have a few minutes left today. I got to ask a sobering question, I think, for anybody who cares about the judicial system. Is the Missouri plan in trouble? So last month, many people in St. Louis and St. Louis County voted against retaining two Missouri Supreme Court judges, Ginger Gooch and Kelly Broniak. They'd ruled against putting the abortion rights amendment on the November ballot. They were in the minority on that. But there were a lot of people who were pretty wound up about that and thought, hey, let's not retain these two judges. Let's send a message. Well, now, coming from the other side of things, incoming Senate President Cindy O'Laughlin wants to scrap this whole system of how we retain judges and how they come through these sort of expertly chosen panels. She says the very fact that this constitutional amendment on reproductive rights made the ballot shows that the state's highest court is out of touch with the electorate. She wants judges to come straight out of the people rather than voting to retain, that we would choose among candidates just like we do for Missouri governor. Mary Anne, are you worried about this?
Yeah, I am. The Missouri plan is a nationally recognized way to select judges. And really, when I look back over my career, and I've been practicing more than 45 years now, the results of the Missouri plan tend to be good jurists who, although they may have a particular political bent, are not ideologically driven. They're trying to do the right thing. I was on the panel in the city that selected candidates for 6 years. There's lawyers and lay people and a judge on these panels. And it is a really rigorous process. And the people who are doing the selection take it very seriously. And, I know a lot of people who would say that I'm a person with strong opinions. And it's true. I do have strong opinions. But, we were very deliberate when we were selecting candidates. And it wasn't like we ended up with any wild-eyed ideologues in the process. So I think it's a great system.
Dave, conservatives have been a lot more critical about this system for a while now. Do you think they have a good point?
I think there is room for improvement. So, and the way that I explain this is the Missouri plan, I think, was a definite improvement over judicial elections. Judicial elections is a bad way of choosing judges. But my other panelists here may know Jim Layton, who served for more than 20 years as Solicitor General of the state. He argued at least 4 cases in front of the U.S. Supreme Court, hundreds of appellate cases in the lower courts. If anyone was ever qualified to be a appellate judge in Missouri, Jim Layton was qualified. He tried 14 times to be named to a panel through the Missouri plan, Never once did his name make the final 3.
So not to open a can of worms when we have 1 minute left to wrap this discussion, but what was the problem there for him?
No one knows.
No one knew. Okay.
No, because the system does not require the panel or the commission to explain its decisions.
Yeah.
So I think that there's room for improvement. I think the question is, what form should that improvement take?
Well, and I'd love to dig into that in a future show, and maybe we will. I will say I come from Ohio, where judges would run $1 million advertising campaigns on TV, and their donors were all the lawyers that were about to appear before them. I really don't want to go to Ohio, and I see everyone nodding. Nobody wants this to turn into Ohio.
All you have to do is go across the river to Illinois, and you'll see it in action. It's not a good thing. It's not a good thing.
And that is Mary Anne Sedey of Sedey Harper Westhoff getting the last word on today's show. Mary Anne, thank you so much for joining us.
Thank you. It was fun.
And Dave Roland of the Missouri Freedom Center, thank you for joining us.
Thank you, Sarah.
And Liz Lenivy of the Simon Law Firm here in St. Louis. Liz, thanks so much for joining us.
Thanks for having me.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr. This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.